Okay, just to skip on, just to move on our activities. As I told you, we are the investment promotion agency of Lombardy region. So we are supporting for free foreign companies that want to set up a new business within our region. We do these activities thanks to an helpful collaboration with public partners as well as with private partners. This is just an overview of our services. From one side, we support companies that request our support to, for example, to find their location within the Lombardy region, to recruit new personnel, as well as to support companies that want to expand, so companies that already invested in our region and they want to expand our business. This is our partner program. As I told you, we have a network of more than 20 private partners. Orrick is one of our partners. And we work with them because we support our clients together with our private partners. Just a few words related to our new project called Land in Lombardy. All this information you can find, of course, on our website. Land in Lombardy is a project that is actually provide you the possibility to test the local market. You are offering the opportunity to come here and to have a free office space up to 3 months in one of our most important technological parks, as well as a business incubator within our region. So basically, you have our support related to our activities. So just a few words to conclude my introduction. We are Invest Lombardy. We are the investment promotion agency. We support foreign companies what they want to set up a new business. We also provide you information related on the business opportunities that we can offer to you. So please, you can get in touch with us. This is all our YouTube channel. We have a LinkedIn group as well as a Twitter channel. So please feel free to contact us. Now I give the floor to our colleague from Orrick, Mr. Federico Perego, Associate Orrick. Thank you so much.
Good morning, everybody. This is Mr. Perego speaking, and together with my colleague Daniela and Andreatta that will follow me, we will discuss about debtor restructuring proceedings in Italy. In order to do this, we have divided this webinar in 3 parts. In the first part, we will deal with an overview of the major reforms that have improved the bankruptcy law in order to make it more debtor-friendly and investor-friendly. In the second part, we will discuss the major and commonly used restructuring proceedings today available in the Italian market. And in the last part, we will approach 3 case studies in which the 3 main restructuring proceedings that we will have discussed at the time will be applied to specific cases. Now let's move to the major reforms that have characterized and has improved the bankruptcy law in the last 10 years. Before doing this, it is important to understand the 2 main types of insolvency proceedings that are provided for by the Italian law. One are the proceedings that we are going to discuss in this webinar and are pre-insolvency proceedings. The main characteristics of these pre-insolvency proceedings is that they are all aimed at the restructuring of the debt of the debtor in order to allow the latter to continue its business. Some of them can be also used for liquidation purposes, but the characteristic common to the 3 of them, which are the certified plan, the debtor restructuring agreement, and the so-called concordato preventivo, is that they can all be used to restructure and prosecute the debtor business. On the other hand, there are other types of proceedings, which are pure insolvency proceedings, and fallimento, the pure bankruptcy, amministrazione straordinaria, which is a bankruptcy dedicated to large companies, and liquidazione quota amministrativa. The common characteristic of all these proceedings is that they are all aimed at the liquidation of the assets of the debtor. One of these proceedings can be also used for restructuring purposes, but the main characteristic is that they are thought for the liquidation of the debtor assets. That said, we can move to the major reforms that have characterized the last 10 years in order to improve the bankruptcy and make it more debtor and investor friendly. The first major reform, and the most important one, because this is the turning point in order to have a different approach to insolvency, is the reform of 2005. In this reform, I'm sorry, I've been told that I shall stay a bit closer to the microphone. The first major reform that we have to consider is the reform that dates back to 2005, in which the old concordato preventivo, which had very strict requirements, has been improved in order to make it more easy to be approached by the debtor. Then it has been introduced a new restructuring proceedings, which is the debtor restructuring agreement, which is a special proceedings that we're going to discuss afterwards, and is characterized by a semi-out-of-court proceedings. Then another important point that has been improved in order to facilitate the restructuring of insolvent debtor is concern clawback action. In this reform, the so-called suspect period has been reduced. Suspect period, which before the reform was 2 years for abnormal payments, abnormal transactions, and this suspicious period has been reduced to 1 year, and the other suspicious period, which was for all other transactions, has been reduced from 1 year to 6 months. Following this important reform, there has been another reform in 2006 in order to improve the liquidation process of the pure bankruptcy proceedings. In this context, what should be noted is that it has been introduced in the Italian system a new instrument, which is called concordato fallimentare, according to which a third-party investor can make a proposal to the court in order to buy out the debtor estate. After 2006, there has been a few further reform, but to see another major improvement in the Italian bankruptcy law, we have to wait until 2012. In 2012, a new instrument has been introduced in the Italian system, which is called concordato in bianco, where that will be discussed afterwards, and I can anticipate that is a kind of version of the US Chapter 11, in order to allow the debtor to obtain a standstill period in order to negotiate with. Then it has been introduced a special regulation tailored for debtors that are willing to restructure their debt and prosecute their business. And so specific provision in order to protect the debtor in this restructuring phase has been introduced, and some of them will be highlighted afterwards. Then has been introduced the possibility to terminate and to suspend certain agreements, certain pending agreements that with the view of the restructuring of the debtor business are no longer appropriate, useful, or necessary. Then it has been introduced the possibility to obtain new finance in order to finance the restructuring of the business, and that this new finance can be ranked super senior in case of bankruptcy. debt in case the restructuring process is not successful. Further to this, there has been additional improvements that are mainly related to certain tax advantages for the debtor and the creditors of the debtor, certain other advantages in terms of corporate duties while managing an insolvent company. Then it has been introduced special provision in order to facilitate the approval of the settlement with creditors, that is also called concordato preventivo, by providing that not casted votes are considered to be positive votes. And then, in order to increase the reliability and the possibility of success of these restructuring proceedings, it has been the law now provides for not only civil liability but also criminal liability on the experts, in order to increase the level of diligence of the experts certifying the restructuring plans. Finally, we have to mention a final reform. This reform took place in 2013 and mainly concern the so-called concordato in bianco procedure that we have mentioned before. And this reform was mainly aimed to make the benefits related to this procedure more stringent. And this in order to avoid certain abuses that have been made by the debtors under the previous regulation, which was kind of too permissive. Now that we can understand how the Italian system tried in the last 10 years to improve in order to make the restructuring of the business of the debtor more favorable and more easy to achieve, and also allowing third-party investors to help and support the debtor, we can move on and discuss the three major insolvency proceedings that are available to insolvent debtors. These three insolvency proceedings are the so-called certified plan, which is in Italian is piano attestato, and these proceedings is an out-of-court debt restructuring proceedings regulated by Article 67 of the Italian bankruptcy law. After that, we will briefly discuss the so-called Accordo di ristrutturazione dei debiti, which is debt restructuring agreement. These proceedings, different from the previous one, is a semi-out-of-court debtor proceedings, which is regulated by Section 182 bis of Italian bankruptcy law. Finally, we will briefly discuss the so-called concordato preventivo, settlement with creditors, which is a fully in-court restructuring proceedings regulated by Section 160 and subsequent of the Italian bankruptcy law. Moving on, we will approach the certified plan that we have said is an out-of-court proceedings that can be initiated only by the debtor with the aim of restructuring its debt with the view of prosecuting its business. This is important to note because the majority of scholars argues that the certified plan is not available for debtors willing to liquidate their assets. The certified plan can have any content, can provide for any kind of transactions that are necessary to restructure the debtor-indebtedness. This plan may involve certain or all the creditors and or third-party investors that are willing to support the debtor in these proceedings. One of the advantages of this kind of restructuring proceedings is that the debtor is not bound by the so-called pari passu principle. That means that the debtor is not obliged to treat all the creditors, let's say all the unsecured creditors in the same way and all the secured creditors in the same way. They can apply in this plan different treatment to different creditors. Further to this, important to note that this plan to be effective and to grant the debtor and third party dealing with the debtor certain advantages must be certified by an independent expert, which shall be appointed by the debtor itself. The benefit of this certified plan, and in terms of facilitating the restructuring of the debt of the debtor, is that any transaction performed pursuant to the certified plan is exempted from clawback, meaning that third party can safely deal with the debtor without the fear that the payment that they will receive will be clawed back by the court in case of subsequent bankruptcy. The other important advantage that facilitates this kind of proceedings is that if the plan is certified and is appropriately certified, meaning that the certification by the expert is serious, is well done, it's appropriate, and considered all the important data and events that can affect the feasibility of the plan, it grants the criminal liability upon the debtor and dealing with the debtor, that in that very moment is an insolvent debtor. Finally, one of proceedings is that can be strictly confidential, and so it does not have to be publicated at a certain register or filed at it can be kept confidential. Our assessor or the third party willing to obtain certain tax advantage because in that case the certificate at the company register. Now that we have provided you with an overview of the certified plan, we can move to the second restructuring proceedings that we were willing to with you, which is the debt restructuring agreement. But before doing that, we would like to speak a bit about an interim in court proceedings that is not a restructuring proceeding itself, but can be used in order to obtain the standstill for negotiating with creditors, with the aim at finally standstill period, or sorry, within the standstill period, finally a restructuring also that can be a debt restructuring agreement or a concordato preventivo. The application to the court to obtain this standstill period, quite simple application that must be filed with the court and then published with the register of the company, and together with the application shall be filed at court certain documents, but easily produced by the debtor. This standstill period can last from 60 days, which is the minimum standstill period provided for by the law, to 120 days, which is the maximum period provided by the law. In order to obtain these 120 days, the debtor must be able to justify the needs of this additional time to the court. Another improvement to the law in order to facilitate the restructuring proceedings is that also during this period, the debtor can obtain finance ranking super senior in case of subsequent bankruptcy. However, we have to stress that in our experience, it is very difficult, if not impossible, to obtain this new finance during this phase, because the court has not enough information on the future restructuring agreement in order to allow this further risk on the creditors. As said before, at the end of this standstill period, the debtor must file his proposal. And as said, this proposal can be either a concordato preventivo or a debt restructuring agreement. The debt restructuring agreement we have mentioned it before. It's in Italian it is called Accordo di ristrutturazione dei debiti. Different from the certified plan, it's a semi-out-of-court proceedings, which is again initiated by the debtor. The main requirement of these restructuring proceedings is that the debtor must reach an agreement with at least 60% of its creditors. In 60%, not in number of creditors, but in amount of claim. And it doesn't matter if these creditors are secured creditors or unsecured creditors. The other condition is that the agreement shall allow the full payment of all remaining creditors, meaning the creditors that have not approved the debtor restructuring agreement. This payment shall be made, the law provides, in order to further facilitate the restructuring, the positive outcome of the restructuring agreement. The law states that the payment of these remaining creditors shall be performed within 120 days from the date of confirmation by the court of the debt restructuring agreement, if at that date such credits are already due, or in the case at that date the claims are not due, within 120 days from the relevant due date. Also, this agreement shall be filed at court and finally approved by the court. Together with the filing at the court clerk shall file the same proposal at the register of the company. From the date of the filing at the register of the company, it starts another extensive period which lasts for 60 days, within which the court will hear possible objection from creditors or third parties against the confirmation of the debt restructuring agreement, and eventually, if the objection, if any, are rejected, approve the plan, approve the restructuring agreement. Similar to the certified plan, one of the benefits, the most important benefit of this debt restructuring agreement is that all transactions performed pursuant to the debt restructuring agreement are again clawback exempted, and the debtor and the third party dealing with the debtor are not subject to criminal liabilities, but for, let's say, receiving payment or giving new finance or accepting to perform transaction with an insolvent party. Now that we have provided you with this overview of the debt restructuring agreement, we can move to the last debt restructuring proceedings provided for by the Italian law. These further proceedings is the so-called settlement with creditors, which is in Italian concordato preventivo. Concordato preventivo is, let's say, the more invasive proceedings because it's a completely in-court proceeding. This proceeding is supervised by the court and appointed by the court. Be a public hearing in which the creditors will have to vote in favor of the settlement agreement. And what I want to stress in this, by saying this, is that this proceeding is less confidential or less confidential than the other proceedings. It's more invasive, but on the other hand, will provide certain benefits that the other two proceedings won't provide, and we will argue about this benefit afterwards. The main requirement of this concordato preventivo is that, as well as the previous agreements, is to be validated by an expert, and it must provide for the payment in full of the secured creditors unless these secured creditors are impaired. This plan set shall also certified by an independent expert, which is again appointed by the debtor, and the independent expert shall certify that the plan is feasible and the data on which it is based are true and correct. The concordato preventivo proposal shall be filed at court and again at the register of the court. After the vote it should be found by the court. The concordato preventivo is approved and will be proposed if approved by at least 50% plus one of the unsecured creditors. Similar, and this is the main advantage with of all other restructuring proceedings. I'm making the main advantage because they are different to the other ones. Here it is not required to pay the creditors that had voted against the concordato in full. The majority binds the minority in this case. Also in this case, if the concordato preventivo is approved by the majority of the creditors and then is confirmed by the court, grant the debtor and the third party the benefit of the clawback exemption and the exemption from possible criminal liabilities on the debtor and on the third party dealing with the debtor. With this, I have concluded this brief overview of the Italian restructuring proceedings available to debtors. And I leave the floor to my colleague Daniela Andreatta that will provide you with 3 case studies applying the 3 restructuring proceedings that we have spoke about. Bye, thanks.
Good morning, everyone. My name is Daniela Andreatta. I run the insolvency practice here at Orrick. And now that Federico explained to you how the system works, we thought that it would be useful to see how it actually play out in reality. Oops. So let's start with the first one. Oh. This one? Mm-hmm. Okay. Uh-oh. Here it is. All these cases we had and we worked on, so I should actually know them pretty well. The first one is a piano testante, it's a certified plan. It's an SME, so our debtor, the debtor side. The debtor is an SME and he is a manufacturer of high quality inline tax. I put down some of the key financials just for you to give you a flavor of what we're talking about. The sales were around 10 million, the bank debt was to 7.3 million, and the suppliers were around 2 million at the time we started looking at this. So as you can tell, the company it was to serve the debt. Something happens? Okay. And the lawyers. And the financial advisor looked at the business and realized that the business required major changes and came up with a plan. What does the plan provide for? First, a change of the organization of the business. The advisor realized that the business was not productive. There were too many people doing the same thing. And the marginality was way too low. So they changed the organization of the business, called in a new manager who introduced a lot of new procedures and processes and made it much more efficient. Second thing the plan provided for was a cost reduction. As you will see throughout this case studies, cost reduction is something that happens all the time, unfortunately. And unfortunately, again, it affects employees. So in this case, they had to lay off 15 employees and they went through a spending review process. They start cutting costs everywhere, starting from external advisors. First thing they had to do and put in the plan was to change the business model. They realized that they were selling to clients, to markets we had too many competitors, so they thought to launch new products and to approach new clients. And finally, the bulk actually of the plan was to restructure the bank debt because the 7.3 million were way too high. And especially in this case, the bank debt was a short-term debt. There was a mismatch between sales and the due date of all this bank debt. So what did the debt restructuring agreement provide for, which is what I put at the bottom of the page? First, we rolled over 6 million, 7 points, to 2020 interest period next year. Second, luckily enough, confirmed the short-term percentage, although we used them at 1.5. It is paramount for any company in a difficult situation to have the short-term facilities, what we call the self-liquidating facilities, in place, and these are usually the first ones that the banks tend to reduce or tend to stop when the company is into distress. So this restructuring agreement provided for the confirmation of these facilities, and finally the banks required the shareholder to have some skin in the game, which is usually a request you will have all the time coming from banks. And our shareholder gave a mortgage on a personal property as collateral for the rollover debt. The steps of the proceedings, as I said, first thing, debtor called in the financial advisor and the lawyers. Then first thing we had to do was a standstill with the banks. Federico just explained to you that a certified plan does not have any standstill. So you have to make sure that the banks don't start attaching assets of the company. And we had to negotiate with the banks a standstill agreement, which we eventually signed. Then we were in parallel actually. The financial advisor was working on the plan. We had the expert certify the plan. We signed the bank restructuring agreement with the banks, and to take advantage of the tax advantages, we filed it with the register of companies. Now, the timing of this type of procedures, unfortunately, is not the most efficient. It depends on how many banks you're dealing with. In this case, we had at least 12 banks, and it took us 12 months. We first negotiated a standstill, and that took a couple of months just for the standstill, and then it took us almost a year to go through the entire process. So the difficult part, what takes a lot of time, is the negotiations with the banks when you have a lot of banks, which is usually the case in Italy. Italian debtors tend to work not with one bank, but rather with many banks. So the second case study is on a debt restructuring agreement. Debt restructuring agreements in Italy are called 182 bis agreements. So that's you will hear a lot about them. The debtor in this case was a large company, as we are talking about a company with 500 employees, with a lot of financial troubles. The company was a leader of in the manufacturing of some plastic materials. It was an European leader in some of in a niche of the business. Unfortunately, it was losing margins, it was losing profits. The shareholder was distracted by his football team, and he tended to use the money of the company to support the football team that, as you may know, usually don't make much money. So it was a huge problem. The management, which was run by the shareholder, and the profit and loss of the company. The key financials were sales 200 million, a bank debt of 162 million, and suppliers around 51 million, again heavily indebted. So in this case, because of the way the company was run, and actually the lack and the absence of a real governance, what we had to do was to really change the corporate structure. This is something that came up during the discussions with the bank, because the main focus of this restructuring plan was actually the bank restructuring agreement. we had 60% of the creditors were represented by banks. It is usually the case that the banks, when you start talking to banks, they represent the 60% threshold. So we started talking to the banks, and what the banks required was a change in governance, a discontinuity, we call it. And the way to do it was, where we started to do it was first to change management. So the shareholder was kicked out of the directors, shareholder, sisters, and parents were kicked out of the management. We called the CRO. And then we started to go for a real corporate restructuring. So the way we did it was, we did spin off the assets, the going concern, the business, into a new co. And we kept all the real estate in old co. The point for doing this was to free the business from the bulk of the debt, which we left in old co, and to allow the business to keep running. Despite this, the business needed, as usual, a cost reduction process, so we had to lay off 200 employees. We had to close a couple of plants and to concentrate production in the remaining 2 plants. So what the banks agreed to was to keep the bulk of the senior debt in OldCo, where all the real estate was, to roll it over, and to allow repayment of the senior debt just through the sale of the real estate and the sale of NewCo. Banks had a pledge on the shares of NewCo and had a mortgage on the real estate. We rescheduled the junior debt, which had gone down in NewCo with NewCo, which was not a major amount actually. And then the banks were willing enough to grant new money to NewCo to support NewCo. And this is what the agreement, the restructuring agreement, actually contains. The agreement is always subject to confirmation by the court, which we actually eventually received. So that's the proceedings I just explained. We first changed the management and negotiated with banks, went for the plan, had the experts certify it. We filed that restructuring agreement with the Court of Milan, with the Register of Companies, and then had the Court of Milan confirm the plan. The timing, again, is not very efficient timing. We first had to discuss and negotiate with the banks, which went on for at least 8 months. And then we had to go through the court proceedings, which were here in Milan. Court of Milan, the Bankruptcy Court of Milan is one of the most efficient courts. The 4 months are due to the fact that it was a summer period in August. Italian courts tend not to work, and that's why we took 4 months, so a year to go through this case. And finally, the last one I start to mention is the Concordato Preventivo case. We are working on it. The debtor is an SME. It's a manufacturer of industry plants. Agri-food plants. The sales are 7 million, so they used to be 40 million, and then they went down, unfortunately, dropped down to 7 million. So when we started working with this debtor, the sales were very much reduced. It's a problem. The problem they have is with the financial crisis and with the investments. Their clients, for many years, it's getting better now, didn't have access to any credit facilities due to the financial crisis, and that's why they didn't buy this they're huge plants actually. The bank's debt is way too high for this company. It's 6 million, and the suppliers are 1.5 million. When we were called in by the debtor, this company started having severe problems with the creditors. Creditors were threatening to attach the company's assets. We started talking to the banks, but realized, there are not so many banks actually, but we realized that it would have taken way too long to discuss with them, talk to them. So we had to go for a Concordato Preventivo. What the Concordato Preventivo, the plan filed with the court, provides for is the sale of the French subsidiary, which is actually the most juicy asset of the entire group. Again, we had to change include a change of a business model because they have to look for new clients in new markets. The most relevant action of the plan is the sale of the business. They will be selling a business to a third party in the context of the concordato preventivo. We already found the third party purchaser, so when we filed the plan with the court, the purchaser was already there, and we filed the agreement together with the plan. So what was the proposal to the creditors? What is actually the proposal to the creditor? It's a payment in full of the secured creditors and a payment of 15% of the unsecured creditors, which is pretty much average in the concordato preventivi recently. It's around 10 to 20%. This is what is actually offered. The first step of the proceeding in this case was a concordato in bianco. We had to file for a concordato in bianco because creditors were threatening to attach the assets, and we had to protect it and protect the estate, obviously. When you file for a concordato in bianco, not at that time, but now you have a commissioner called in by the court, and that's because Italian debtors abused of this instrument. Everybody was filing for a concordato in bianco without even having any view on whether they could restructure the business or not. So now it's becoming a little more stringent and strict. The court calls in a commissioner, and the commissioner actually supervises whether the company really is looking to restructure or is just buying time. So we filed for our concordato in bianco, received and got our 4 months of standstill. At the end of the day, we filed the proposal. The creditors voted in favor, and eventually the plan got confirmed by the court. Again, the court proceeding is, we are not in an efficient court in this case. It's a court of Pescara. It's unfortunately not very efficient. But per se, a concordato proceeding in court should not take more than 6 months. And then we had the additional 4 months of the automatic stay proceeding. So these are the case studies, and I'm done with them. What happens now? You'll come back. Bye-bye.